morning of June 3, 1961, the owner of the Bay Harbor pool room in Panama City, Florida, arrived at work to find that his business had been burglarized. A window had been broken, some bottles of wine were missing, the jukebox and cigarette machine were smashed, and several dollars in change had been stolen. Later that day, a nearby resident reported to police that he had witnessed a local drifter by the name of Clarence Earl Gideon walking away from the pool hall at about 5:30 that morning. When Gideon was located by police, he was in possession of a pint of wine and had a pocket full of change. Gideon was placed under arrest and charged with breaking and entering the pool room with intent to commit petty larceny.
Now, in the past, he had had some run-ins with the law. He had been convicted of theft, of breaking into places, but this had given him enough experience with the law to know that he needed a lawyer to help him in court. And so when he was arrested on this charge, he asked the court to please appoint a lawyer for him.
The judge said, well, can you afford one? And he said, no, I have no money. And the judge said, well, in Florida, I can only appoint a lawyer for you if this were a murder case. And since it's not a murder case, not a capital case, I have no authority to get a lawyer for you. You have to represent yourself.
Gideon said that I have a right to appointed counsel under the Sixth Amendment in this kind of case. That really wasn't correct.
The Sixth Amendment says that in all prosecutions, the accused is entitled to the assistance of counsel. The first 10 amendments to the Constitution, however, by their terms only apply to the federal government. So when the Sixth Amendment said that the accused shall have the assistance of counsel, what that meant when it was written was that the assistance of counsel would be provided in prosecutions by the federal government.
This, of course, is a state case. So the question is, to what extent is the Sixth Amendment guarantee of the right to counsel incorporated or applied against the states under the Due Process Clause of the 14th Amendment? And the Supreme Court had started down that road in the famous case of Powell versus Alabama in the 30s, the famous Scottsboro Boy case, where it held that at least in a case involving capital offenses, where the death penalty was being sought, the state was required to appoint counsel. Then in Betts versus Brady, 10 years later, the court adopted the so-called special circumstances approach. Basically said that if there is something unique about this case, if it's a very complicated case legally, or if there's something that makes this a very much out of the ordinary kind of case, then we will appoint counsel. We will require that counsel be appointed, but not in the run-of-the-mill case. And that was the rule from when Betts was decided in the 40s up until Gideon.
Now, Mr. Gideon did not present a special circumstance within the meaning of Betts because it was a very low-level offense. Many of the cases where the court had previously said there were special circumstances were death penalty cases. Many of them were cases involving sort of an overlay of racial injustice and a concern about discrimination against the defendants. And Mr. Gideon was a white man charged in a relatively uncomplicated case.
Having no choice but to represent himself, Clarence Gideon attempted to argue on his own behalf, asserting his innocence and questioning various witnesses, including the police officers who had arrested him. But despite his best efforts, he lacked the skills, knowledge, and experience to mount an adequate defense. Mr. Gideon was found guilty of breaking and entering and petty larceny, a felony in the state of Florida, and was sentenced to 5 years in jail.
He decided that he was not happy with that result. So he prepared something called a writ of habeas corpus. And so when Gideon filed his writ of habeas corpus, he wrote, I wanted a lawyer. I asked for a lawyer. I didn't get a lawyer. Therefore, this violates the Sixth Amendment of the Constitution, which says that a criminal defendant has the right to counsel. So Gideon wanted to be freed from jail because his constitutional right was violated.
The case then goes through the Florida courts and ultimately gets rejected by the Florida Supreme Court, who didn't even write an opinion. Again, presumably because The issue had been so clearly decided in Betts versus Brady, and this is just how the system worked. So poor people in felony cases almost never were entitled to the appointment of counsel.
Sitting at a small table in a prison cell, Clarence Gideon prepared a handwritten petition on prison letterhead, asking the Supreme Court of the United States to consider his case. The court agreed, and also agreed to waive the fees associated with his petition. Attorney Abe Fortas was appointed to represent Mr. Gideon, and in 1963, the case of Gideon versus Wainwright came before the U.S. Supreme Court.
So the irony is that this man who couldn't get an attorney for a little trial in Florida was appointed Abe Fortas, one of the greatest lawyers of his generation, who later became a United States Supreme Court Justice. This is the person that the Supreme Court appointed to represent Clarence Earl Gideon because they recognized that he was raising an important issue, and they wanted it to be thoroughly researched and really well argued when it came before them.
The court usually specifies exactly what it is that it wants to hear discussed. And in this particular case, it was quite explicit. It asked, should the court reconsider Betts versus Brady? So it sent out the message at the outset. We're interested in hearing argument on whether we ought to overrule this case.
So the question before the court was again the question, does the right to counsel found in the Sixth Amendment of the Federal Constitution apply to the states via what we call the incorporation doctrine via the 14th Amendment? And the court had said previously only in capital cases, not in any other case.
Arguing before the court, Attorney Abe Fortas contended that Mr. Gideon's Sixth Amendment right to counsel had been violated when his original request for a court-appointed attorney had been denied. During his oral argument, Mr. Fortas described the American criminal justice system as inherently adversarial, meaning that both the prosecution and defense work to present the best case possible for their side. He then claimed that Clarence Gideon, a man with no background in the law, could never be expected to prevail when facing an experienced, formally trained prosecutor in court. Standing before the 9 justices of the Supreme Court, Mr. Fortas said,
"Of what happens to these poor, miserable, indigent people when they are arrested and they are brought into the jail and they are questioned, and later on they are brought in these strange and awesome circumstances before a magistrate, and then later on they are brought before a court, and there, Clarence Earl Gideon, defend yourself."
What he was saying is that when you put someone who is not a lawyer into a system in which that has been constructed so that there are two sides pitted against each other, on the notion that by this debate, by this going against each other, being adversaries, you will come to the truth. That's what our adversarial system is all about. We believe that knocking of heads, that going after each other, produces for the jury an idea of what really happened. So he was saying that's the way our system is made. And so what we have in a criminal case where liberty's involved, and there's no lawyer on the defense side who knows all the tricks of the trade, all the procedures, all the ways to make an argument, has been trained and worked in it for years. We have no one on that side who has that skill, and someone on the government side who does have that skill.
Think of it as a sports match where you give one side a glove and a baseball and a bat, and the other side gets only the glove. It wouldn't be a fair fight. The person with the bat would always win. Well, in an adversarial system where the defendant doesn't have an attorney, it's as if the defendant is trying to play baseball without a bat. He's not going to be able to hit the ball hard enough with his hand. You have to give the same tools to each side.
Mr. Fortas said that because of the 14th Amendment's due process clause, every defendant has the right to a fair trial, and that without proper legal counsel, no person could receive one.
The 14th Amendment, which was enacted after the Civil War, guarantees all citizens protection of due process of law and required the states to provide due process of law. What the defendants in cases like Mr. Gideon's were saying was that that requirement, that the states provide due process of law, effectively meant that the states had to comply with these provisions of the Bill of Rights. So Mr. Gideon was saying, because the 14th Amendment says that the states have to provide due process of law, that means that they should have to provide me with the right that is contained in the 6th Amendment.
And the question is, what was the court going to do about it? Was it going to continue on that line of not applying the 6th Amendment to state criminal defendants, or was it going to incorporate the 6th Amendment into the 14th and apply it to state criminal defendants? And the court, in a unanimous opinion in Gideon, decided they would apply the 6th Amendment to state criminal defendants, and they reversed Mr. Gideon's conviction because he had no attorney at his original trial.
Justice Hugo Black wrote the opinion for the unanimous Supreme Court. The court concluded that defense counsel was a necessity, not a luxury, and was fundamental and essential to fair trials. Writing for the court, Justice Black observed,
"Governments, both state and federal, quite properly spend vast sums of money to establish machinery to try defendants accused of crime. Lawyers to prosecute are everywhere deemed essential to protect the public's interest in an orderly society. Similarly, there are few defendants charged with crime who fail to hire the best lawyers they can get. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him."
Having won in the U.S. Supreme Court, Clarence Gideon was retried in the same courtroom and before the same judge who had originally heard his case. This time, however, he received a court-appointed attorney who was able to effectively argue on his behalf, and eventually Clarence Earl Gideon was acquitted.
Gideon, by its terms, only applied with respect to felonies. The question was, well, what about misdemeanors? Okay, it's one thing to appoint an attorney in a felony case, fairly serious criminal case, but what about the run-of-the-mill misdemeanor case, of which there are just tens of thousands? Do we have to appoint a lawyer in every single one of those?
And there were many decisions back and forth for a number of years after Gideon. It's now settled that if a misdemeanor will lead to you being in jail, then that criminal defendant has the right to an appointed lawyer. If it's a misdemeanor like a parking ticket, then you don't have the right to a lawyer.
Gideon is a landmark case, really because it's a symbol, I think. It's a symbol of equal access to justice for all, that everybody in this country gets a fair shake in our court system, whether they're poor or rich, black or white, sophisticated or unsophisticated, that everyone is equally treated under the law and everyone should have the same breaks as everyone else.
In 1963, a few months after Mr. Gideon's acquittal, Attorney General Robert Kennedy said this about the case. If an obscure Florida convict named Clarence Earl Gideon had not sat down in prison with a pencil and paper to write a letter to the Supreme Court, and if the Supreme Court had not taken the trouble to look at the merits in that one crude petition, among all the bundles of mail it must receive every day, the vast machinery of American law would have gone on functioning undisturbed. But Gideon did write that letter. The court did look into his case. He was retried with the help of competent defense counsel, found not guilty, and released from prison after 2 years of punishment for a crime he did not commit. And the whole course of legal history has been changed.